Melissa? Melissa? There you go. Just show that, not me.
Well, too bad.
Now, Melissa, you are to destroy this video immediately upon viewing it, okay? Do not want to see this on Sean Hannity. I do not want to see it on Glenn Beck, any of these other stations, okay? All right. I think she understands. Slade, we were just talking about you. How you doing? No class tomorrow, remember that. All right, well, guys, let's get going here. You're probably wondering why this is the most important class. I think as we get into this, you'll see what we're talking about. Tonight, a little bit about legal research and presentation. Normally, this type of subject would be taught in political science, right? They have to take a whole class on legal research. You're not going to need all that much, but you will have to know how to read a court case and then present it in written form. Those are called your briefs. And then toward the end of the year, when you're doing your presentations, I'm assuming it's going to be a topic on the subject of environmental law some type. So that'll be an oral presentation. So we are going to look at how to find statutes and regulations, but we won't spend a whole lot of time on that because really I want you to know how to find the court cases. Find them, read them, analyze them, and then present them as briefs, right? So once you pick up what we talk about in this class tonight, you're going to have clear sailing the rest of the semester. Remember this from last week? Any questions before we go forward? This is the basic setup of the court system, right? Hopefully you've studied that and you've got it down because next week I'm throwing you right into a court system that you've not studied before, and that would be the New York State court system, which is different than Texas, which is different than the federal system, but the same principle's the same. Trial court, intermediate appellate court, highest appellate court. Once you have that down, you've got any case within your grasp. All right, so let's talk about statutes. When we say statutes, remember last week we mentioned statutory law. Where do we find these statutes? For instance, where would I find the Clean Air Act? What's it called? It's a federal statute found in the United States Code. So we find these in books that are called codes, statutes at large. In Texas, we call them Vernon's statutes. Sometimes they're known as the Black Books because typically in hardbound form, Vernon statutes are in black covers. That is the statutory law. If I asked you to find the Health and Safety Code, Water Code, Natural Resources Code, any of these would be in the statutes. I'm going to show you how to find these online. By the way, any of this stuff, if you don't want to find it online, you can go to the 6th floor of the library. Anybody visit the library anymore? You've been to the library this semester. What do you do in the library?
Study.
Really, is that the purpose of going to the library these days?
That's my purpose.
Okay. How can you study? Because people are walking around, you see friends, or then you get in one of those little study carols and then you got this beautiful view of the hill country. How do you actually get any studying done in the library?
It's better than anywhere else.
All right. It's just focus. Same question I usually have of University of California at Santa Barbara, Pepperdine University. I mean, they overlook the Pacific Ocean. How do you study in those contexts? All right, so statutes. We're also going to talk about finding regulations. What's the relationship between a regulation and a statute? Melissa? You don't know, do you? Just kidding. By the way, the screen's blank. Is it supposed to be blank?
Well, see, I think it's just because it's,
Okay.
see, it says 4 minutes.
Say hi to
30
Melissa.
seconds.
See, I'm going to be doing all kinds of different stuff because I'm
Let me see if I
doing this for Melissa now. What's the relationship between a regulation and a statute? Come on, we talked about this. Statutes are much broader, more general. Regulations flesh them out. Who writes statutes? Legislatures. Who writes regulations? Agencies write regulations. So for instance, you have the Texas Clean Air Act, Chapter 382 of the Health and Safety Code. If you want some guidance about how that Clean Air Act operates in Texas and pertains to the regulated community, you would go to 30 Texas Administrative Code, Section 101 through 111. Okay, those are your regulations that flesh out that particular statute. Okay, so that's the relationship going on. Statutes written by the legislature, regulations written by the agencies. Where do we find these? I'm going to give you 6 choices. I do have my preferences, of course, but you can find them any of these 6 ways. First of all, official government websites. What might I be talking about? So for instance, if you wanted to find some Texas statutes, is there an official governmental website? Yeah, I think I gave it to you there. It's hosted by the Texas legislature. What about regulations? What agency hosts regulations? Secretary of State. All right, so if you really want the origin of these things, you'll go to the official government website. However, a lot of people prefer to use LexisNexis or Westlaw. Any of you have any experience using either one of these? Okay, which one? Lexis? Both? And I have a strong preference for Lexis over Westlaw. I mean, a very strong preference, so much so that we're only going to go through the Lexis part. I'm going to show you how to do this really simply from the university website. You can also go to agency websites. So let's say you want to know a regulation written by the TCEQ. You think going to the TCEQ website might help you? Absolutely. You want to know something by the Department of Energy? Go into their website. They will provide a link to that particular regulation that you're looking for. So those are good. By the way, when they do the link, they typically link back up with the official governmental website that it originated from. Law school websites, Pace School of Law, Vermont School of Law, University of Texas, University of Houston. Any law school will typically have links to any statutes or regulations that you need to find. But once again, they will link to the official government website. There's something that I'm going to show you in a few minutes called FindLaw. Any of you ever been to FindLaw? Right? FindLaw.com. Pretty handy little site if you're interested in all things legal. And then, of course, the last resort is Google. I don't discount Google. If you put in a good search term, even if you put in a bad search term, it really doesn't matter. You're probably going to find what you need. Just make sure it's something current. Because when you ask for, say, a particular statute, a particular regulation on Google, if you don't read carefully, you might get something that's out of date. So just take that with a grain of salt. And I could have put in Wikipedia and any of these things. They will always link back to the official government websites. All right, so here is, for statutes, there is our legislative website. And I gave that to you in my list of websites. So you basically type that in. You could even do Texas Online, and it would take you to this legislative website right here. When you go to there, you'll see that they have a drop-down box. You don't want to get into the Texas Constitution unless you have many, many weeks and you want to be bored out of your skull. You don't want to go to that. You do want to look at Texas statutes and see they are put into groups called codes. So you'll have your election code, family code, finance code, government code. Really, the ones we are going to be looking at are your water code and your health and safety code, things like that. You can either do it from there or you can choose this drop-down box. So let's say we wanted to find the statute that pertained to the case that supposedly you read, the LCRA case. What was that? What was the main law in that case? Texas Water Code 11.134. All right, so look, you go to the legislative website, you find the water code, you drop down and look. There's chapter 11. All you have to do is click on that. You will get another drop-down box. You go down to 11.134 and it says action on application. In other words, someone has made an application to withdraw a certain amount of acre feet of water, just like in our case. Well, there's the actual statute, and you can find it again through the legislative website if you are interested in doing that. Or let's say the case doesn't give you the full law in its recitation. You can do that. And when you click on it, look at that. There's your action on application. So again, you didn't really see this full thing in the case, did you? They usually don't have time to write it all out. So if you just wanted it there for analysis sake, you could do it, print it, and have it right with you. Pretty good thing. There's nothing like going back to the original law when you're trying to interpret a case talking about that law. I like to read it for myself sometimes, right? And so it's a good thing to do. Now here's another way of doing it. You can go to the Texas State website, go right over here, and by the way, I'm sending you these PDFs, to the library. When you click on library, you're going to have something called research databases, okay? Any of you ever done this? Research databases, you can go alphabetically if you know what you're looking for, or if you're looking for something pertaining to law or government, you can go to that subcategory. So you go there, and you will have many choices, one of which will be Westlaw, which I choose to not use.
The reason why I like Westlaw is because in the key sites, it gives you the actual law, or, like little sections.
I know all about West Keno. I grew up on Westlaw. By the way, I don't want to get sued. Here, I'm talking there. I really love Westlaw. I just choose not to use it. Okay.
LexisNexis is easier.
It is, isn't it?
It's a lot easier.
And so, because of my preference, this is a personal preference, I'm not endorsing any one product. See how video recording changes things? This is why I don't like trials being recorded. People start acting differently and weird.
Talking to the camera.
I have chosen to use Lexis. So there it is, LexisNexis Academic. That's what you guys have. Now I have a special form of LexisNexis for people who work in government. And let me tell you, it's a lot easier to navigate than the one you guys are given. But you have to work with what you have. So you click it, and there you are in LexisNexis Academic. And you're saying, by the way, Neil, why aren't you going live with this and doing it? I try every once in a while to go live with a demonstration, and something always happens. The internet goes down, something's not there that I need, and it just never works out. So I said, I'll just capture the screen and send you guys the PDFs, and that would actually be more helpful to you in the future than me going live. Now after class or during the break, I'll be happy to go live if you want to see something. All right, so here you are in LexisNexis Academic. Now what are we looking for? Statutes or regulations, right? We're going to save this for later. Keep this in mind, but save it for later. What you want to do is go down to U.S. Legal right there and click that. And when you do, again, you will get some drop-down boxes, and you see state statutes, codes, and regulations. They even let you choose your state. Well, we've chosen Texas. Say we want to find a statute. We'll click right there and browse through those, or we'll browse the administrative code for regulations. But we've chosen statutes. So here you go. Does this look familiar? Looks kind of like the setup of the legislature right there. Drop down boxes, find your water code, click on your particular section, 11.134. Voila, you're in. So what's the difference? Well, when you're in LexisNexis or in Westlaw, they will have commentary. In other words, look, we're going to give you more than just the statute. We're going to give you a listing of cases that mention this statute, that talk about this statute. Think something like that would be helpful? Oh, absolutely. If you're doing legal research involving case law and you want to know how this statute's been interpreted, knowing all the cases that mention that statute is extremely helpful. So that's something that you get in Lexis and Westlaw that you're not going to get from the straight legislative site. I think you're probably going to be doing most of your research in Lexis this semester. Again, here's something else besides cases that mention that statute. They're going to go through law reviews. You know what a law review is? It's like a scholarly publication that's done at a law school, like a law school journal. And all the best and brightest minds, not just law students, but lawyers, publish in these law journals. So just like the AAG, American Association of Geographers, what's their magazine, their journal called? Is it called the AAG? The Annals of Geography, right. So you get all your scholarly stuff in there. Same way with law review articles. So not only do you get cases, you get every law review article that may have mentioned that statute. Doesn't mean that's what the law review article is primarily about. It just means it mentioned it at some point in time during the article. So again, helpful when you're doing research. Now let's move to regulations. By the way, there's our Secretary of State right there, Secretary Barry. What do? You go to the website and you click on State Rules and Open Meetings. State Rules is really what you're looking for. And so when you click on that, you'll get the Welcome to the Texas Administrative Code, and you can view the current Texas Administrative Code. Now in a few weeks, we're going to learn how something gets into the Administrative Code. It just doesn't appear there one day. There's a process that goes into it before it arrives in the Administrative Code. But if you want to see what's current as far as regulations are concerned, go to the Secretary of State's website, click on that, and then you can view the current Administrative Code. There it is. It's got titles, okay? For people who are interested in environmental law, your main title is going to be Title 30 because that's where the TCEQ deposits all of its regulations. And so that's the one we're really, really going to be interested in for this semester. Clear? Melissa, questions? I'm going to be doing that. All right, so anyway, again, when you get into 30 administrative code, you can drop down into different chapters and look at different things. It didn't really have a whole lot of application to the case that you looked at for tonight's class, but in the future, it probably will. All right, so again, if you go through Lexis instead of directly to the Secretary of State, go to U.S. Legal, Statutes, Codes, and Regulations. What do? You want Texas, and you want their regulations that we know are found in the Administrative Code. Again, you get a similar drop-down box like you would on the Secretary of State's website. Just giving you some options on how you can find the same thing. And again, drop down into specific chapters. All right, I breezed through that because it's something interesting to know, but it's not primarily what you need as your basis of knowledge for succeeding this semester. You need to be able to look up court opinions or the cases. So I'm going to show you how to look those up tonight. Once again, as cases are published after the justices vote on these things, they are put in reporters. We either have state reporters, each state has their own set of reporters. Sometimes they regionalize them, like Texas, Louisiana, Arkansas, they would be found in something called the Southwestern Reporter. But there's actually a reporter called the Texas Reporter too that just reports Texas cases. So you have your state cases, then you have your federal reporters. More about that a little bit later in the lesson. So where do you find the cases? Well, guess what? Some of the same sources that you would use for statutes and regulations. But I'm only going to give you 3. Lexis or Westlaw, FindLaw, interestingly enough, or Google. You know, again, you can find just about anything on Google, so no need to worry about it. As I was teaching this class 13 years ago, I couldn't tell students that, and they really did have to worry about, if they couldn't find it online, going to the 6th floor of the library and actually looking it up via book form. All right, so what do? We go to Nexus Lexis Academic through the library research database. And here we are. Now remember, where did we go for our statutes and regulations? Down there. When you're looking up a case, listen very carefully. Do not go down there. You will become hopelessly lost and confused if you try to find cases going down there. You may succeed, but you really have to know what you're doing. the easiest and best way is to go to this middle column right here, and it says look up a legal case. Now you can do it by mentioning the parties, or you can mention a topic. Once again, that will be extremely time consuming. And if you don't put in the right defendant's name or the right plaintiff's name or the right appellant's name or appellee's name, you're going to be in for a long, long search. And what if you don't quite know the topic, right? It can lead you on some wild goose chases. So the best way to find a case is by citation. They gave you an example there. Volume 163, that's the U.S. Reporter, that's page 537. Throughout the semester in your syllabus, I've given you the citations of the cases I want you to either look up, be familiar with, read, or brief. Okay, and I gave you the exact citation. Now, I'm going to tell you this many, many times tonight. When you give me a citation as part of your brief, you're going to have a name, you're going to have something like this, and then you're going to have in parentheses what court it's from and what year it's from. There's a formal way of doing that. Also, if you're writing a research paper, you're going to use that form. And I gave you some citation forms on how to do it. But if you're looking up a case, you don't bother with the names and the years and all that. You just use two numbers and the reporter. So again, the first number is going to be your volume number. In the middle is going to be the type of reporter you're looking for. And the second number is going to be your page. That's all you need to put to find the case. Anything else will cause confusion in the system and therefore confuse you. All right, so what I did was take the citation of our case for tonight, the LCRA case, and I put it in there. Did you guys try any of that? Now, this will be a once in 10,000 case. And why I say that is typically when you put in a specific citation like that, it will bring up the one and only case. But this case had some problems with it. As it went from bound volume to online, the numbers got mixed up. Okay? Who can figure that? And there was a motion for rehearing, and it was granted, and it changed the outcome of the case. So they did it again. So guess what? When you put this one in, it brings up three cases. You're saying, how am I ever going to know which one if this ever comes up? Well, look, you have to use your common sense with this. Let's say I had assigned you the LCRA case as a legitimate case to read and to brief. So you know I'm giving you a real case. All right, let's say you went to choice number 1 and you're reading about it, and it's all about a nasty divorce battle. Think, okay, let's see, did the LCRA have anything to do with this divorce, property, and custody battle I'm reading? But probably not. So it might cue you in that you're not on the right case when we're studying water quality and you've brought up a divorce case. Okay? Just use your common sense. So, same thing with this. Let's try number 1. So you click number 1, this is all there is. And what does it say? The document reported this citation has been withdrawn from the bound volume. I told you there was some confusion there. So if I asked you to brief this case, there's one sentence. And it says it's no longer here. So if you turn in a brief to me saying, well, that was it, it's no longer there, no, you didn't do your work. Let's go to the second one. That's all you're going to find. On motion for rehearing. Obviously, that's not the case you're looking for either. Third time's a charm. Let's try the third one. This is starting to look like a case. You have a case summary and it goes on, okay? So again, if you bring up more than one result, and you do that in rare occasions, but if you do, use your common sense as to what's supposed to be there. And if you're hopelessly confused, I don't mind if you ask me during the week, Neil, I'm on this case and it doesn't seem like it's the right case. Okay? I don't mind answering these questions at all. Just think before you do it. By the way, you can do it in many languages right there. Is that cool? I'm serious. They had literally over 100 in LexisNexis things, and all you have to do is go right up here, and it says choose, and they give you a drop-down box of any language that this case would appear in. So say you're more comfortable in Spanish, you can choose Spanish. If you happen to like Japanese to read your cases in, great. You can choose it and read it in Japanese. I've chosen traditional Mandarin Chinese right there. So that's pretty awesome. I didn't even know until last semester that they had included that thing. And it only makes sense since we have so many international students. We're going to want to give more choices as far as looking at the case. Okay. So anyway, here's the case. We brought up the case. Now I do need to mention this. You're going to see this word pop up from time to time in cases, and it's going to be a choice for you. You can shepherdize the case. This is like the Turabian method. You know, Kate Turabian had that whole method named after her. A guy named Shepard had this methodology named after him. Now, back in the old days when we shepherdized cases, we have to go look for these maroon books. They look like Texas Aggie books sitting there. You know what the purpose was? To make sure that the case we were looking up was still good law. Because what do courts do sometimes with prior cases? Overrule them, overturn them, right? And the last thing that you want to do in front of a judge is give her bad law. Trust me, they'll check it out, they will find you, they will expose you, and you'll be in a lot of trouble if you give the judge bad law. Even by accident, you'll still be in trouble, okay? So you're going to want to make sure that your research is up to date. And that's why you shepherdize, to make sure that everything is still up to date. Now look, this case, and I wish they didn't do this so much. I remember back in the day when the red stop sign meant, whoa, this case has probably been overturned. That's not what it means anymore. It just means there's been some negative treatment of it. And I think what they mean by negative treatment is Justice Ray, in this case itself, treated the majority opinion negatively. I think that's all they meant for this. But there are little symbols there. And so anytime you see this red symbol, you're going to want to say, okay, I want to check out these other cases and make sure this is still good case law because there was some negative treatment. When you see that Q, it means it's been questioned. Doesn't mean it's been overruled, overturned. It just means it's been questioned. Okay? Possible negative treatment. Positive treatment. Okay, so they're giving you all the little things as you're doing research to see if this is good law, if it's strong law, if it's about to be overturned, or it's going to be just steady for years and years and years. That's what you do with shepherds. Kind of an interesting little feature. I won't be asking you to use it much, but it's kind of a neat thing to know. Now, on this one, what did we have? We had 8 opinions after the LCRA case that mentioned them. And so you go and look, here you have the city of Marshall versus the city of Uncertain. I've been to Uncertain, I think. I'm not really sure. I have been to Uncertain up there. But what you're seeing right here is, look, the Texas Supreme Court in these 2 cases cited that LCRA case that you read. What they said about it, well, you'll have to look it up yourself, okay? But they just mention it. Here's some Court of Appeals cases that mentioned that LCRA case. Again, you can look them up. Very good for finding out if you've got good law and doing further legal research. And once again, Shepard's does this. When you shepherdize a case, it will point you to law review articles or environmental law journals that happen to mention these cases here. So here's 2 of them. And some of them are in blue, some of them aren't. I guarantee you if I was with the county LexisNexis, these law review articles that are in black would be in blue, and I could click and immediately go to them. But on your LexisNexis Academic, you can eventually find these, and if you're ever interested, I'll show you how to find any law review article. But these you can just click on and go directly from the case to this law review article right there. Okay? Pretty handy thing to have. What's that the citation to? next week's case that you're supposed to brief. So you're going to find your case. You can scramble around. You could put the word boomer in there. Lord knows what you would come up with. I don't know. You could put nuisance in there. I don't know what you come up with. You might get a picture of the Texas Supreme Court. Who knows, right? The quickest way to find your boomer case is to put in the citation. And look at it. It's exactly the same thing I gave you when I assigned the case to you, except what don't we have? We don't have the name of the parties. We don't have the name of the court. And we don't have the year. What do we have? Volume, reporter, that's the Northeastern Second Edition, and the page number. That's all you put. Volume, reporter, page number. You can find any case that way. If you're not finding it, you better go back and check yourself. You might be putting in the wrong volume, wrong page, because if you put in 871, it may or may not come up with much of anything. If you don't do your spaces right, look, page, space, no spaces here on the reporter, then space, and then there's your page. Right? Volume, space, reporter, space, page. I gave it to you. If you don't do your spaces right, it may not come up with it. So practice on it when you get home tonight. And voila, when you come up with it, there's going to be your case that you're supposed to brief for next week. By the way, remember when we shepherdized our LCRA case? How many prior cases, or how many subsequent cases did we come up with? 8, right? You shepherdized the one you're going to do for next week. Look at this. Just law review articles, 556. That tells you it's a pretty well-known, prominent case, and I'm telling you it is. It's a landmark in certain aspects of environmental law, the Boomer case. That's why it's so heavily publicized there. All right, now I told you about FindLaw, www.findlaw.com. I think I used it as one of the websites that might be helpful for you. I use this all the time, and in fact, if you go to the FindLaw website, you can enroll yourself to get newsletters for certain types of law. I get something on a weekly basis called the Green Sheet, okay? Gives me all the important environmental law news and court cases. Say you're interested in bankruptcy. Why? I don't know. But if you're interested, you could probably get on a mailing list like that. But FindLaw lets you do that. It's really for the common person who wants to know a little bit about law. But we're not going to proceed that way. What you do if you use FindLaw is you visit the professional site. Even though you're not licensed attorneys, they don't really care. And once you do that and visit it, you get to find all kinds of cool stuff. Now, why would you look up your case via FindLaw as opposed to Lexis? Any guesses? Well, then I'm going to tell you. When you go through Lexis, did you notice the case? There's lots of commentary. You know, you got your case summary, your little blippets, your head notes, and all that stuff. Some people don't like reading a case that way. They just want the straight old case, right? None of this collateral stuff, none of this commentary, none of these editorial features. And so the best way to do that is go into FindLaw. Now, I'm going to tell you, they're trying the best they can to enter every case in the country. But they're a little bit behind on the states. And so where people do this is with Supreme Court cases, because I guarantee you will find every Supreme Court case on FindLaw. So you go to Supreme Court. This is going to be one of the cases that you brief later on in the semester. You could find it through Lexis, or you could do here. Now, this is going to look a whole lot different on FindLaw because basically here's where the case starts. You won't have any of those editorial features that we're going to go through. I have many, many students who prefer to actually read the straight case on FindLaw rather than do it on LexisNexis or Westlaw, just because that's the way their mind works. Okay? Giving you the choice, though, on how to do it. All right. Remember this? Get this out if you have it. You don't have it, do you, Catfish?
Syllabus?
Yes. It's on your computer?
No, it's holding it up.
It's holding up the computer.
I
Sorry,
have it.
Melissa.
Hold on.
We cannot sacrifice Catfish's education for your sake. Sorry. All right, cool. All right, find this common citation forms. And what I've done, look, there are formats for doing this. If you really want to be a legal, and do all this stuff for the rest of your life, you have what's called the Uniform Code of Citations. For federal cases, it's called the Blue Book. You have a specific one for Texas called the Green Book. If you'll remind me at some point in time this semester, I will find mine. They're packed. I'm moving Monday. Anyway, they're packed, and I'll bring them in. But we use those if we're doing heavy-duty legal research. This is all you are going to need for the semester right here. I've given you just about every type of citation there is. So let's just go through these. Each state is going to have its citations. I've given you 3 Texas citations. Look, here is your Intermediate Court of Appeals in Texas, just called the Court of Appeals. What do we know about this case right off the bat? It's a divorce. Luker versus Luker, right? That way, you know, Johnson versus Johnson. When you have those kinds of cases, they're usually family law cases here. Now, we don't know if this is Mr. or Mrs. Luker here, but we know this Luker lost at trial, right? Because the loser is the one that typically appeals. So they appeal. Well, where do we find this case? Well, we know the reporter. It's the Southwestern Reporter, second edition. By the way, they get to $9.99 and then they start over. So you get to $9.99, then you go to the second edition, $9.99, third edition. We're on the third edition now, working our way to the fourth. So what's the 776? It's the volume number. What's the 624? It's your page number. But this is your formal citation. And so I have to put a little bit extra. If I'm going to put it, say, at the top of a page, or I'm going to cite it in a report or some research paper I'm given. So what do I have to say? This is a Texas Appeals Court. Which one? The one that sits in Texarkana. What year did this case come out? 1989. What do you think this means? Writ denied. The loser, whether it was Mr. or Mrs. Luker, I don't know who lost, tried to take it up to the Texas Supreme Court, and they denied the writ. So you remember the highest court doesn't have to take the case. They only take it if they want it or it interests them or it's some big question. They tried to take it up, and it was denied. So this is the law right here. So by the way, if you were finding this case, if you were looking it up on Lexis, what would you put? Only this information, 776 space Southwest 2nd space 624, right? You wouldn't put the Luker and the 1989 Texarkana, none of that stuff. This is just your formal citation. Here's our case for tonight, Lower Colorado River Authority, Okay, so it's the same thing, something a little different here. This is what you put when it's the Texas Supreme Court, just TEX dot 1984. Just for fun, I gave you a criminal law case. But remember, what's your highest criminal court? Texas Court of Criminal Appeals. So there's Parks. This guy's the loser there. He probably lost a trial, appeal, lost there, decided to go up to the Court of Criminal Appeals. So he is the appellant. Parks versus State, there's your volume, your reporter, your page number, there's the court, and there's the year. Right? Now, this gets us into the federal system. Now, what did I say was different about federal trial courts than state trial courts? They do what after a case is finished? They write an opinion, and it's published in a reporter. So this is your trial court right here. What do we know about Tunnel? Tunnel was the plaintiff. Robinson was the defendant. Where can I find this? Well, it's a reporter that gives these trial court results that are written by the trial court judges. It's called the Federal Supplement. Volume, reporter, page number, what does all that represent? Remember, we have 94 district courts across the United States. Where's this one? Western District of Pennsylvania, 1980. Okay. Now let's say we appeal Courtney versus Bishop. What do we know about Courtney? Courtney lost at trial. And so we're bringing it up. Again, volume, reporter, page number. Except this reporter is called the Federal Reporter. Okay? So you got the Federal Supplement, the Federal Reporter. What is this information telling you? Which circuit court? The 8th Circuit, and that's telling you the year. What's the difference between these two? There's only one difference. I gave you an extra number. That is called a pinpoint site. And that's when you are quoting. Say you're quoting something from this Courtney versus Bishop case. Uh-oh. Am I supposed to stand up and walk around? Oh, I can. She doesn't need to see me. As long as she can hear me.
Did you say pinpoint or
Pinpoint site. So let's say you are giving a direct quote from Courtney versus Bishop, and it's on page 1187. That's what you would put. The case starts on 1185, but the quote you're giving is 1187. It's only used when you're quoting, okay? And then finally, the easiest citation method is actually United States Supreme Court, right? We got the parties, volume, reporter, United States reports, page number, year. We don't have to say district or which circuit, or because there's only one U.S. Supreme Court. How about this one? Get a load of this one. You'll see these every once in a while, mostly in law journals and things like that. It's a citation with subsequent history, so you can actually read it and know a little bit about what went on in the case. There are your parties. We know it was tried here because this is federal supplement. We know it was the Northern District of Oklahoma. However, somebody appealed it up to the 10th Circuit. What did the 10th Circuit do? They reversed it, right? They reversed whatever this trial court did. Whoever lost there or was unhappy tried to bring it up to the United States Supreme Court, and the cert, writ of certiorari, was denied. So again, you're not going to have to worry about this too much, but just recognize it when you see it. Gives you a little bit of history that you didn't have before with that case. All right, so you have this sheet, and you can study it at your leisure. Bathroom is a good time to look at these things, just saying. All right, I know everyone's tired. I'm tired too, guys. I really am. We're gonna plow through on elements of a court opinion. Look, it's real simple. Every court opinion, whether it has 10 pages, 100 pages, 1,000 pages, all come down to this. They are going to state the facts. They're going to tell you the applicable law to that particular case or deciding that particular issue. They are going to give you what the issue is in the case. It may be 1, it may be 2, it may be 5 issues, but they're going to express these issues. Then they're going to decide. Remember, they can affirm, they can reverse, and then they can answer the questions that they're raising in the issues, right? That's a little broader answer. So, if you ask me a question, I could say yes or no. Well, that's kind of curt, isn't it? I kind of cut you off. If you ask me a question, I'm going to say yes and give you a little bit broader answer to it. So that's usually what the courts do. Then, this is the big part of the case. They take a lot of time in the case explaining why they answered that question the way they did. They're very good about justifying their decisions. Then there's going to be your concurring or dissenting opinions. Remember, if it's not unanimous, you're going to always have a dissenting opinion. What are concurring opinions? You agree with the result, you don't agree with the reasoning. Okay, you're going to see these in every case. The only time you won't see dissenting opinions is when it's unanimous. And again, I'm going to send you this. So don't worry if you don't get down every word. So let's do our LCRA case. Should I go easy on you or hard on you tonight? Should I expect that you've actually read this case? Or since it's early in the semester, assume you probably haven't. I did tell you to, didn't I? So I should have high expectations. All right, now I'll proceed with that. And whoever looks like they don't want to answer, I'll focus in on them. By the way, that's an art in law school, is when you're not prepared, not getting called on. And sometimes you think, okay, if you raise your hand and do this stuff, but they do just the opposite. They'll call on you then. It's embarrassing. We used to have a professor named Professor Blakely, and he would call on you randomly. And you read your case. You read 300 pages, and then he'd do some stupid hypothetical, right, that had something to do with the case, but you really had to think. And he'd say, suppose, and you go, no, a hypothetical. And he asked this impossible thing, and he'd say, Miss Catfish. And you go, oh boy. And you hoped what you said had something, some semblance of what he's looking for, okay? Sometimes a lot of my classmates would say, sir, I'm not prepared. Mr. Casera will mark you down as unprepared. 2 more unprepareds and you will fail the course. And he wasn't kidding. So then you sat in mortal fear the entire semester of getting called on and not knowing the answer, and it would just add to your angst and anxiety. That's the law school experience, okay? Let's not do that. Let's not do that. All right, here's our case here. Now, as you looked at the LCRA case, remember what I told you? It had that, say, find law doesn't? These are called editorial additions. Subsequent history, case summary, head notes, all these little different things. And I call this the lazy person's part. Because if you really don't intend on reading the case, I guess you could get by with reading some of this. And, I have to admit, if the judge asks me for something and I have actually never read the case and I literally have 10 seconds to be coherent about something, I'm going to be into reading that case summary, because at least I'll be able to say something to the judge. My preference, obviously, is to have enough time to read the entire case, but time is not always something that we're blessed with, okay? Actually, once you get past those editorial features, you will get to something called opinion. That is when the case actually starts, actually begins, when you see opinion. And typically right after that, you see the justice who wrote the opinion. In this case, it's Justice Kilgarlin. Now, what are these notes, these little numbers here? Sometimes you will have N1, maybe in the written one I gave you it was N1. Or sometimes you'll just see it as a little bitty 1. These are footnotes. You guys know what footnotes are, right? You didn't say it in the body of the text and you dropped down to the bottom and did a little footnote. Are footnotes important? Absolutely. Let me tell you, fortunes rise or fall based on words in a footnote. You're going to see that a little bit later in the semester. So pay attention to these footnotes. Make sure they're really footnotes. They'll either be in one or the little one like that. These numbers right here, see these? You don't have to worry about these. Or the ones that do HN1. You don't have to worry about those. Those are Lexis features, and they refer back to a Lexis editorial edition. The ones you have to pay attention to are these, or like in the older version that I gave you, the ones that say N1. All right, so let's go back through our elements of case featuring our LCRA case. All right, first thing we need to look at are the facts. And remember, just like there are substantive law and procedural law, there are substantive facts and procedural facts. Now, what I need to know in substantive facts is some very basic things. Who all the parties are, you need to identify them, tell me who they are, and what they're fighting about. I mean, we have a lawsuit going on, right? We have a case. Somebody must have a disagreement about something. So, who can tell me who were all the parties in our LCRA case, and what are they fighting about? Okay, They're fighting about unappropriated water. Why?
Because,
One person at a time. Go ahead.
someone wanted to take a certain amount of acreage of water to start with.
Acre feet of water. You know what an acre foot is? Think about a football field, foot of water. That's an acre foot. All right. Who wanted to appropriate this water? No, not the Texas anything.
It's the
Colorado River Municipal Water District. Okay. They wanted to appropriate the water. How much were they asking for? 400,000, 500,000 acre feet. Well, that's good enough. We got plenty of water, right? What's the big deal? Right? We're just flowing. We got rivers full of it. What's the problem? Who was opposed to this?
The Department of Water Resources.
Well, not necessarily.
petitioner.
Who they weren't a party to this. Who actually opposed the application? They were applying to the agency, which back at that time was the Texas Department of Water Resources.
People
The Lower
near Lake
Colorado?
Travis and Lake Buchanan.
Lake Travis Improvement Association. Who was the main person or the main party? Lower Colorado River Authority. Downstream uses. Why would downstream users oppose an upstream user asking for a new appropriation of water? They're thinking, okay, worst case scenario in times of drought, we know what the paper says, we know we have priority, but we know in reality we're probably not going to be getting as much water. So LCRA and a bunch of other parties oppose this. Okay, so you need to be really clear about who all is involved, like the Texas Department of Water Resources. And by the way, how did they do these cases back then, these regulatory cases? They had a division within that agency called the Texas Water Commission that did all of their adjudications. I'm going to tell you, if this had been in 2014, this would have all been done through the TCEQ, would have been the agency to decide whether you got that water or not. And if someone had requested a hearing, it would have been done in front of another agency called SOA. Right? What's SOA? State Office of Administrative Hearings. It's an agency that does nothing but adjudications for other agencies. Okay, so we've really changed things regulatorily since 1984. But that's the way it was then. All right, so we know why they were there. Someone wants water, someone opposes it. So I also want to know what got us up to the point of this case being written. What happened? Okay, it was approved by who? The agency, right? Did you notice they approved it even after staff recommended against it? Did you notice that? Don't you love that when an agency sends their staff out to do hours and hours and hours of research and work? Thank you very much. And then they go against whatever you did. That's exactly what happened here, because staff found there wasn't enough unappropriated water there. And we'll talk about that in a few minutes. All right, so who's unhappy? LCRA and the others who opposed it. So you're seeing a peculiarity in administrative law in Texas, because where do you appeal first from a regulatory decision that goes against you? Did you notice? Where did they go first? The Travis County District Court. Travis County District Court was not acting as a trial court. They were acting as a court of first appeal on an administrative matter. Okay? I don't expect you to know this, but now you do. So they heard it, and how did they rule? They agreed with the agency. LCRA still wasn't happy. So where's the next step from there? Now we get into the more traditional appellate process. It went to the Third Court of Appeals. What did the Third Court of Appeals say? They affirmed.
That's why I went to
They
Supreme
affirmed.
Court.
So LCRA is still unhappy. So where's your court of final appeal? The Texas Supreme Court. Okay? So when I ask you for the facts of the case, that's exactly what I want. I want to know who the parties are, what they were asking for, what the disagreement was all about, and what happened procedurally to get us to this point where this particular court, the case you're reading, wrote this opinion. See that? All right, those are your facts. And by the way, on your brief, you don't divide it in, you don't say substantive and procedural. You kind of blend and weave it all together, like I did on my sample brief, which we'll go over in a few minutes. Now, the next thing that I told you they do is the court states the applicable law. Now, it can either be statutes, regulations, or in common law cases, what would it be? A prior case, right? Because that's what the common law is all about, relying on prior case decisions. In this instance, we've already been through this ground. What was the court saying was the applicable law? Texas Water Code 11.134. And they gave you a condensed version of what that law said. All right, so you got that out of the way. So we know the facts, we know the law, and then we have an issue or issues raised. You apply the law to the facts. These things are either suggested by the attorneys who are appealing the cases, or the justices figured this out themselves. What was the issue of this case? They stated it right up front, didn't they? What constitutes unappropriated water? I mean, didn't the justice say that at almost the very beginning? Yeah, they say it throughout. But, you know, you didn't have to go any farther than the first sentence, basically. Now, it's not always going to be that easy. Sometimes you're going to have to read these cases several times before you can ascertain what the issues are, because not all justices are as plain spoken and clear as this particular justice was. You were lucky for this one. Oh, you don't think I would give you one that is difficult, do you? I'd never do that to you. Yes, I would. All right. So then the court has raised an issue, and it's typically in the form of a question, right? What constitutes unappropriated water? Then they answer the question they asked. And there's going to be a two-part answer. First, you're going to have your immediate decision. Affirm or reverse. And then you have your broader holding, okay, that goes on from there that gives you a little bit more than yes or no. So what did the court do here? Did they affirm or did they reverse? The Supreme Court. They reversed. They reversed. Reversed in what? Reversed and what? Remanded? Or did they use that term?
Set aside.
Set aside. Okay. Did they do that? Okay, they reversed and set aside, which means remitted. Okay, which means it doesn't go back to the agency again. Done, through. That's it. And what was their broader answer to the question, what constitutes unappropriated water? It is what?
Water is not being used for beneficial
Water
use.
remaining.
It's not already under a prior permit.
All right. So after we look on paper at all the permits, licenses, whatever, the rights to appropriate water, we take all of these into account. Then we look at the water available, we subtract all that's spoken for from the water available, whatever's left is unappropriated water. That was their ruling. All right, good enough. So y'all were following that, right?
So they said it didn't matter that people had their water permitted, but they weren't using all of it?
They did.
Well,
When we go into the explanation. How did they explain? What was the big gist? Why was there so much disagreement? I mean, what was the original water district saying when they were asking for this water? They said, wait. We know what the papers say. We know how much is, quote, appropriated on paper. But you look at reality, they're not even using this stuff. So therefore, if you don't use it, you lose it, right? That was their reasoning. And apparently, They had the agency agree with them, Travis County District Court, Third Court of Appeals. So it wasn't a simple question.
But they didn't tell the people that their permits had
There
been-
you go. That was what the court in its explanation finally got to. We have something in this country called due process. You ever heard of that?
Yes.
Fifth Amendment of the Constitution, guaranteed to each of the states by the 14th Amendment. We have lots of kinds of due process, but one is procedural due process, which means we cannot deprive you of life, liberty, or property unless you have notice and a hearing. Okay. As we looked at the laws, were there statutes on the book which said if someone's not using it, you can go in there and forfeit their right to use it?
No.
Absolutely. No, there were. There were provisions in there showing you how to do that.
How to tell them.
Right? So what the court is saying is, okay, so-and-so, Edward, hadn't been using this for 10 years. Now you can assume he's never going to use it. Maybe he had this great project on his mind and it just never came to fruition. However, before we take his water and give it to someone else, we're going to send him notice. Okay? We're sending notice that we're going to forfeit his right to that water. We're going to give him the opportunity to come and show up and say if he's still going to use it. If not, why not? So let's say Edward has really forfeited this whole thing and he doesn't care about it anymore. Well, he's either not going to respond or he's going to show up and say, I don't need the water anymore. Well, guess what? His permit to appropriate so many acre feet is then canceled and then it gets put back in, quote, the general fund available for use. That's the procedure that was outlined in the code. And if it wasn't the case, why did they even have the procedure? That's what the court's saying. Right? If it just forfeits in and of itself, why have a forfeiture procedure? Right? So that was the gist of what they were saying. And they took a long time to say it. Right? They used 4 different sources when they said it. First of all, what did they do? Legislative history. When you have laws that are unclear, and trust me, the legislature is prone to having unclear laws. They went through the history of this from the beginning of the 20th century all the way to present day. And sometimes you have to do this to really understand. And one thing that people had problems with understanding is why certain sections wound up in different sections and didn't change their meaning. I'm going to tell you, this happens all the time when they're revising statutes. They'll take something and they'll put it from here down to here, and it doesn't make sense where it's at. But it doesn't mean it loses its original meaning. I'll give you an example. If I wanted to criminally prosecute someone for violating the Clean Air Act, which code would I go to? In Texas. I want to criminally prosecute someone for violating the Clean Air Act. They've exceeded their NOx emissions on their permit. Where would I go to find that statute that enables me to do that? The water code.
Really?
Yeah. Right? Because they reorganized it, and it used to be in some other code, and then it ended up in Chapter 7 of the Water Code. Clean Air Act and the Water Code. It doesn't make sense, but it doesn't mean it's any less effective. That's what the court's saying here. Ignore the placement of things. Just go with what it meant. And it meant what it said what it meant back then, no matter where the legislature later moved it to. So they used legislative history. Then they looked at some prior cases. Yeah, case law was kind of iffy on that. Really didn't tell me anything. But I noticed they did a couple other things. They looked at the administrative history. How does the agency, or how has the agency been interpreting this? And they went and found people who were higher ups with the agency, went to lectures that they had given and conferences that they had been given, and said, look, this was their interpretation. Ooh, well, talk about putting the knife in the agency. Then they finally looked at law review articles. So when they combined legislative history, prior case law, administrative history through the agency, and law review articles and law journal articles, that explained their reasoning. And typically in a case, your reasoning is going to be the longest section that you encounter. Just is. Anyone know what this is? Dicta. I mean, sometimes when you're reading a case, you go, huh? That had nothing to do with any of the issues. They're just kind of rambling. Remember I told you President Roosevelt had that court packing scheme? They wanted to do all the justices over the age of 70, wanted to do a replacement justice because he was concerned about senior citizens. Well, it is a fact, not as much today as it used to be, but back then, there used to be some old guys, and they were guys for the most part on there. And old men like to ramble. You're seeing a good example of it right now, okay? But seriously, you ever visit the nursing home? Any of you visit nursing homes? I like visiting nursing homes. And those old guys love to talk and ramble and tell you story after story after story. It's just the nature. Well, guess what? Some of them are justices. And they write this out. And so when you have a bunch of writing that may or may not have anything to do with the subject at hand, it's called dicta.
So they-
One of the things you're going to have to recognize is separating actual reasoning from dicta.
Okay, so
They
they
didn't-
include that kind of information even when it has nothing to do with.
Yeah. But you know what? Dicta can be dangerous because what happens is justices look at this and they will snatch it out of a case where the justice never meant it to be applied to really anything and use it in a case talking about that subject matter, okay? So you got to watch dicta. You may be well-intentioned and like to ramble and talk, but it can be used for ill purposes at times, okay? So if you ever see dicta, point it out in your brief. You'll do that with practice. Then finally, did we have a dissenting opinion? We have a concurring opinion. All right. Who's the smart person in here who caught the gist of the concurring opinion, which was extremely important? Justice Ray said, I agree with the reversal, but you should have remanded instead of remitted or set aside. What difference did that make? I'll tell you what difference. I don't expect you guys to know this. It was a procedural thing that meant everything to the water district, okay? Now look, we know the state of the law now, and we know what they have to do to obtain this acre-foot of water, right? So when this case started, when they first applied for this water, it was 1977. When did this case conclude? 1984, 7 years. So what the justices originally did by reversing and setting aside was saying to the water district, oh, by the way, go to the back of the line, you're free to reapply again. Don't you think a lot of other parties have applied for water permits in that 7-year period? Yeah, they got to go to the back of the line. What Justice Ray says, that's not fair. They've been sitting here waiting for 7 years. So when you reverse and remand, you're going to put them up to the front of the line. And so we're going to pretend it's back 1977. So if and when they do get their water feet, their acre feet, it's going to be ahead of everybody who was behind them in 1977 and got ahead of them through 1984. A procedural thing. Again, I don't expect you guys to recognize that, but that was the importance. And it was so important that they filed a motion for rehearing. It was granted, and then Justice Ray's concurring opinion became the majority opinion on the motion for rehearing, which tells you why it was so confusing with 3 cases.
Is that what this is?
Yeah, that's what that is. And all they did was change how they reversed it to give priority now to the water district. So that's our LCRA case. Tell you what, this is a good time for a brief. This is a good time for a break, isn't it? 7:41, I'm going to give you 10 minutes. When we come back, we will talk about briefing a case. Bye, Melissa. All right, now we're going to start with really the important stuff, the meat of the rest of your semester here, and that's case briefing. Now, I told you, as someone appeals a case, both sides file something called a brief, and that's advocacy-based. You're trying to convince these justices why they should affirm the lower court or why they should reverse the lower court. That's what that brief is, and sometimes you'll run into it in literature or in a case, something like that. What I'm talking about is a good old-fashioned executive summary. That's what you're going to be doing for me 4 times this semester. You're going to be reading cases of varying complexities, and you're going to be boiling that case down into its essence by giving me an executive summary the way I want it done. Slade, forget everything you knew or thought you knew from over in poli-sci. It's all well and good. It's all for their purposes. Follow my rules in this particular class. By the way, you may think, I don't need to know how to do a legal brief. Think of it as an executive summary. One day, you're going to be employed by someone, and it's going to be Monday afternoon, 4 o'clock. You start to look at your watch, thinking about what you're going to do after work, and somebody comes in and says, the boss has a meeting tomorrow, and she has to be ready with this. Here's 400 pages. You need to give her an executive summary of this 400 pages, because your boss doesn't want to show up with 400 pages. She'll never get that. So she wants a condensed version of the highlights of this and the talking points and things like that. Okay, so being able to do this properly is a skill you're going to use the rest of your life. And hopefully one day you'll be the boss who's able to give that 400 pages to someone else who will do that. That's called pay it forward, right? All right, and we all dream of those days. I haven't reached that yet. So, executive summary is what we'll be looking at. Now, what do you get from briefing a case? Well, here's something. I know that you've read the case, right? Nothing else, you have read the case, and I want you to read, at the very least, 4 cases this semester. You may pretend you've read more than 4, but I'll know you've read 4. Secondly, you have a condensed record, and that's good when we're having class discussions. If I say, what did Justice so-and-so say over here? You know, you could fumble through 100 pages of a case, or you could go to your 1-page brief, your 1-page executive summary and say, oh, the court reversed, instead of fumbling through it. It helps you do that. Also, I am teaching you, by giving you these briefs, how to analyze and think critically about these things. Don't be so quick to agree with something just because an educated person has said that's the case. Okay, I want you to think about it. You have something to give of value in this process, and you'll be doing that when you brief these cases. If I wanted to tell you what the purpose of a brief is, it's to give me the essentials. Boil it down to its essence. Don't waste words. I want you to think of your words like water in the state of Texas. We want to use every single drop wisely. I want every word on your brief to count. Do not waste words. That's for the judges to do in their cases. They're very promiscuous with their words, right? You're not going to be that way on your brief. You're boiling it down to its essentials. So, what are the elements of a brief? I'm going to give you these, and then we're going to come back around and review them. The citation. This is going to be kind of easy for you, right? Because in your assignment page, I gave you the citation exactly the way I want it to appear on the top of your brief. Don't deviate from it. Do it exactly the way I gave it to you. Then, the next section of your brief is going to be facts. Remember, what kind of facts are we talking about? Substantive facts and procedural facts. I want to know who the parties are, why they're fighting. I want to know what happened with the lower courts as it came up to this court. That's going to be your facts. Then you're going to state very, very briefly what your rule is. And your rule is either going to be a statute, a regulation, or a prior case. To give you a hint, here's a little clue. Next week, when we talk about common law, what do you think your rule might have been? A prior case. All right, just a little hint for you for next week there. Rule is going to be very, very short. You are going to raise an issue. It is always in the form of a question. You can raise one issue, you can raise 2, you can can raise 3. I don't care how many issues you raise, but here's what I require. If you raise an issue, you deal with it. If you ask the question, you answer it. Where people run into problems is they get crazy with the issues and they raise 6 issues, but they really only answer 2 questions, right? Don't bother. In fact, your space is so limited, I would typically tell you there is one main issue, and I'm going to leave it up to your discretion to decide what the main issue is. Sometimes there's 8 issues, and issue number 8 is how are we going to divvy up these court costs? Well, who cares how we're going to divvy up the court costs? What difference does that make in water quality? None, okay? So I really don't care about those side issues. They're probably pretty important to the parties, right? But they're not important to our case and our main issue at hand and our subject matter. Now, once you ask the question, you answer it in your holding. Remember, you have a 2-part answer. What's the first part? You're either gonna, court's either gonna affirm or reverse, right? That's the way you should start out your holding every time. The United States Supreme Court reversed, comma, holding that, and then you give your broader answer to the question. So you give your immediate answer, then your broader answer, and it's all in the holding. Then, and this is going to be probably the longest part of your brief, you give me a summary of the court's reasoning behind the answer they gave. So they asked a question, they answered the question, and now I want to know, why did they answer the question in the way and the manner in which they did? That's your reasoning. And we went through that with the LCRA case, right? They used 4 bases for their reasoning. And you can sum that up, condense it to me. Ah, this is huge right here. This is how I know you've read the case. By the way, you can use smoke and mirrors for a lot of these things. I know about cutting and pasting, right? Copying and pasting. I know all that. You can do it up to a point. But when I get to the criticism, that's how I know whether you've actually read the case or not. I want to know your opinion about this. It doesn't mean it has to be negative. It just means I want your analytical opinion on this case. Did they do well? If so, tell me why. Did they make a bad decision? Tell me why. You think they made a bad decision? This is huge. This will be a part of every single brief that you give me. All these things, but never leave criticism off. Never, never, never. And then a concurring or dissenting opinion. Now, look, sometimes you're going to have 4 concurring opinions. They're going to be all out there. I would say the dissenting opinion, if there is one, is usually important enough to mention. All right? Not every concurring opinion merits mentioning. And you're going to have limited space. By the way, and I'll answer your question in just a second. The reason I mentioned the one in the LCRA case was because it was important, right?
Yeah.
On the motion for rehearing, the whole court changed what it did based on that concurring opinion. So I would say that's pretty important. Yeah,
So the criticism is our personal opinion and.
it absolutely is.
And concurring is the judges.
The judges, yeah, that's something that the justices write. Criticism, that's all about you. But I'm going to tell you this now, and I'm going to tell you this many, many times. Don't use first person when you do your criticism. I, we, things like that. Do it professionally. All right, so look, here's your elements of a brief. You can brief any way you want. Maybe you've been briefing cases for 10 years, and I don't know about it. Great. Use your tried and true method. Slade, you may even have a method for briefing cases. Don't let me impede on something that's worked for you in the past. Okay? I'm going to tell you how I brief a case. Step number 1, read the opinion. By the way, don't put any pressure on yourself. Just read it for fun. Maybe have an adult beverage or 5, but read it for fun, okay? And that's good. And you actually get a lot out when you don't put pressure on yourself for finding all the answers and just read it. Secondly, what I do, I get a blank sheet of paper and I list all the elements. Remember, what did I say? Facts, rule, issue, holding, reasoning. I list these on the left side, and then what do? I reread the case and I start filling it in. Oh, that sounds like it's a fact. Transfer it over there. Oh, that sounds like it's part of the reasoning. Transfer it down there. Oh, this is the holding over here. So you read the case with the mind to getting your sections organized, okay? Then, once you've gotten all the facts out of the case and put them in the section, you go section by section and get it organized where it flows pretty well. It reads correctly, okay? Because just because you have a sentence in there doesn't mean it's going to read very clearly. In fact, it may be downright awkward. And so work with it section by section and help it to flow. But don't worry about the bottom section where you're still working on the top. Start with your facts and work your way down. This is just me now. After I've done all this, I reread the case and see if my brief then makes sense according to what I've done on my third reading of the case. Wow. I'm going to be lucky to get you guys to even read it one time, right? This is the way to do it correctly. And then you do your final rewrites and your edit. The briefing process is circuitous, okay? Again, you keep going back, adding to, editing, going back, adding to, editing, and that's the way it works. And if you want to do a good brief, that's the way you're going to do it. You want to do a good executive summary in your future sometime. That's going to be the way, basically, that you do it. So what did I do? I gave you a sample brief. You read the LCRA case. There's the brief that went along with that. I'm saying it's the perfect brief, but I wrote it and I think it's adequate because it summarizes everything that needs to be summarized. It got the essence of what the case was saying. Do you agree? I think it kind of did. So look, the first thing you start with is the citation. And I know that's hard to see, but it says exactly how I give it to you. You know what? When I get your first briefs, I'm going to see an incorrect citation because you've gotten it from some other source. Give it to me exactly the way I gave it to you. That's 1/8 of your brief. Already done. Wow. Pretty cool. All right, then we go to the facts. And remember, who's fighting? Why are they fighting? What did the lower courts do? I did that all in one paragraph. What does this mean? When I say stay within the four corners, that means when you're giving me the facts, stay with the facts as are outlined in the case. Now, you may go to Wikipedia or Google and find out some really cool extra information about this case. And I would encourage you to do it if you're interested. Okay, there's lots of stuff about the LCRA case that you could have found out. You could have Googled Stacy Dam and found out all this neat stuff, but it doesn't belong in your brief because it's not in the case that I gave you to brief. So when I say stay within the four corners, that's exactly what I mean. Here's your rule. Look at that. I didn't quote the entire rule to you because you saw that a while ago. It's long. What I did was a very condensed version of this. And again, whether it's a rule or regulation, a statute, or a prior case, be very, very short. Sometimes I see people's rule about this long. And when your rule is that long, that tells you you're not condensing enough. Rule is really, really short. Look at all this. What is your longest section, your biggest section? As I told you, it's reasoning, followed by facts, criticism, concurring opinion. Where's the rule fit in there? Why, the only thing shorter is the issue on that. So again, look at the relative size of what you're giving me there in your brief, and you'll kind of know if you're on track. This is a model brief, not just for what it says, but the size and organization of the various sections. The issue. Your issue is always a question. What'd I say? Your issue will always be framed as a question, 100% of the time. There's your holding. What did I do? I did exactly what I told you to do. We gave the short answer. What did they do? Reversed and set aside. And then I gave you the broader answer to the question that I asked. The question being, what constitutes unappropriated water? So you give the first direct answer, affirmed or reversed, and then you give me a little broader answer to the question. Here's your reasoning why the court gave the answer it did. And again, I went through all of the sources that the court used in a very condensed manner. Treat it like Texas water. Don't waste a single drop. Don't waste a single word in your brief. Briefs shall be brief. Now, here's your criticism. You won't see the word me, I, we, any of those things there. But this is your opinion. I want you to tell me, was the court logical? You know, were they consistent? What do you think their motivations were? All of these things. Really, put yourself out there. Don't be get along, go along type of person. I mean, you don't want to be that kind of citizen in our society, do you? Somebody in authority says something, oh, well, it must be right because they're smart and they know what they're talking about. Maybe they do. Maybe they don't. We need to check them out, don't we? And we need to constantly check them out. That's what you're doing in your criticism section. And then here's your concurring opinion. I told you always do a dissenting opinion, always. Concurring only if it's important and has some merit in the case, because you really don't have room to put in meaningless concurrences. Is that simple? It is now. Maybe it won't be between now and next week as you're writing your brief, but it seems pretty logical right now. Now, look, next week you're going to turn in briefs. There's going to be mistakes on them. I'm going to have to grade these things. And, you know, I'm trying to watch a little football, trying to relax, trying to grade your briefs, and I'm going to see some really bad mistakes. I'm just going to tell you, the only way I get through the first week of briefs,
I knew it.
Ah.
I was thinking about that.
just
I'm
saying,
gonna go grab a drink.
because I have to, okay? I just couldn't survive. So let's look at some common mistakes. That is a big one. It's good stuff. Procrastination. You guys know what that means, don't you? What are you doing? You're not working on the brief during the week. You're waiting till the very last minute. I have found students in this class down in the lab reading the case 30 minutes before class for the first time. What kind of brief, what kind of product do you think you're going to have procrastinating like that? It's going to be really bad. You may be able to cram for an exam that way. Your brief will be terrible. I'm not saying my briefs are your life. I would never say that. You've got life, you've got other classes. I understand all those things. But the sooner you work on it and the more consistent you are at working on it throughout the week, the better. Big mistake. Oh my God. That's a big one. What did I tell you about citations? That's the very first thing I see on your brief at the front, top. What does that say? Exactly. Who's it going to be? Who's not going to give me a citation exactly the way I gave it? Is it going to be you?
No, I think
Melissa.
Is it? Somebody's going to do it. And then, you know what? You've set the tone. Catfish can't even repeat back simple information I gave her after I've told her 8 times. I wonder what the rest of this brief is like. You see, first impressions are pretty important. You know, you go out on a date, that First impression tells you everything, doesn't it? Sometimes your first brief tells me an awful lot about you. Make it a good first impression. Oh, God. I am a stickler for spelling. People don't spell check anymore, do they? Not by eye. They use spell check. Don't you? Get in a hurry, use spell check. Does that correct all your problems? So here's some of the ones from briefs through the years. Trial court becomes trail court. From becomes form. Statute becomes statute. This is my favorite. This poor kid, I don't think, this young man, he was really young. I don't think he had ever actually shaved in his life. He looked like he was still going through puberty, basically. And he had impotence. He kept saying, the court put a great deal of impotence. And of course, I had snarky remarks throughout his brief. I didn't call him on it during class. I would never intentionally embarrass someone. But I put remarks and sarcastic stuff all throughout there. Because every time importance came up, and it was about 8 times, and I shouldn't say came up, that's probably, sorry about that, Melissa. Anyway, he would put impotence. He was so embarrassed. He turned this bright shade of red that I think he learned, okay? He used spell check, and it didn't catch stuff like that. Eyeball it, okay? I am huge on spelling things correctly. If you don't, someone's going to notice it. What if you send in a resume to someone and you have typos in it? Bad first impression. Now, that goes for grammar too. Okay, there's several of these, so I'm going to have to pour a little bit more. You know, these bottles don't last as long as they used to when you're grading briefs. That's probably that. I work for the Travis County DA's office. This is all okay. I really don't. By the way, if you're recording, I'm just kidding. And by the way, Melissa, believe it or not, this is not actually tequila. Okay? Did y'all catch on to that? Okay? It's water. You can come test it. If I held my liquor that well, I'd be an outstanding hero. But this is only water. You know, one time I went, and one guy really thought I was drinking. He goes, dude, you can hold your liquor. I said, absolutely. And he never realized that this was water the entire time. So I did have naive people in class. All right. Grammar. I do not want questions in your brief. Only one time, and that is the issue is always a question. The rest of the time, I don't want questions. What was the court thinking? What the fuck was the court doing? Excuse me. Look, I know y'all never hear that word. I've actually had someone put that in a brief, and I kind of agreed with the sentiment, but you don't actually put it down. You can think everything you want. Don't put it down in writing. This is huge. No first person. I, we, you. I never want to see any of that. You know where you tend to do that? Your criticism. I think, we think, you should have, I don't want to see any of that. No first person. You listening to me? No incomplete sentences. One time I had to derail this class and teach a whole lesson on English grammar. Okay, this is a complete sentence. You have 2 parts to a complete sentence. First, you have the subject, then you have the predicate. When you have a predicate with no subject, that's an incomplete sentence. When you have a subject with no predicate, that's also an incomplete sentence. We had to go through high school English, junior high English, okay? Because people were giving incomplete sentences. And I'll call you on it. If you have an incomplete sentence, I'll say incomplete sentence. Don't do that. Do not start sentences with words like and or but. Those are improper beginnings to sentences. Slang. Don't drop F-bombs like I just did, okay? I had one student say the court was pissed off. Perhaps they were, but don't say it, okay? No slang. And sometimes I'll say slang, and sometimes when you're on the verge of slang, but you're not quite there, I'll say slangish. You know, which which means you're getting there, not quite there yet. No passive voice. Y'all know what the passive voice is? When you turn the object of a sentence into the subject. Now, why did the chicken cross the road? There's the way you say it. Let me change it around to the passive voice. Why was the road crossed by the chicken? Did I say the same thing? Well, kind of. But now I'm putting emphasis on the road instead of the chicken. And lots of people talk in the passive voice. That's one thing that really bugs me about Sarah Palin, among many things. She speaks in the passive voice, and it just irritates me to death. It's like fingernails on a chalkboard every time I hear her speak. Okay? Some people write like that. Do not do that. I'll send you a little supplement on how not to do that. What's this? Anything wrong with a semicolon? Very misunderstood little character. There's a use for semicolons in novels, fictional literature. Now, my boss and I always argue. My boss loves semicolons. I hate semicolons. However, if you use it properly, I will not count off. But I'll have this, and I may shed a tear because I don't like semicolons. Either put a colon, you need one, or put a period, or a comma. Don't put semicolons because I hate them. Okay? Some of you are going to do that just to bug me, aren't you?
I hate them.
All right, I hate semicolons. Just a word to the wise. Proper tenses. What could I possibly mean by that? Well, I'll even show you. Each section of the brief has a proper tense, either past or present. None of them will have future. Your facts. What are we talking about? Things that happened historically, either substantively or procedurally. Naturally, those are going to be past. So your fact section should be past tense. Your rule, as you're looking at this case and telling it to me, is present. I know it was written in the past, but right now as you're giving it to me, give it to me in the present. So therefore your issue, that's your question, will be in the present. Your holding will be in the past. Likewise, your reasoning will be in the past. Criticism, present tense. And then concurring or dissenting opinions, past tense. Just telling you, based on experience, this is the way your brief will read correctly. Okay? I can't point to you a book or any scholarly authority that says this is the way it needs to be. This is the way I like it. And therefore, because you're writing it for me, do it this way. Humor me. You might actually make an A. Right? In the future, if your boss wants you to do something, do it her way. Right? Don't say, oh, Professor Casera said that. No. They don't care what Professor Casera said. Do it her way. Okay? So this semester, do it my way. Right? So that's what I mean by tenses. I'm going to send you all this. Here's some more common mistakes here. Party confusion. Doesn't mean you went to the wrong frat house and hit the wrong party. That's not what I'm talking about. Remember I told you early on, identify your parties. So like for next week, you're going to have a party named Boomer. Okay? Call him Boomer. If you want to condense it down, that's fine. Put it in parentheses at some point. Refer to him as Boomer throughout the brief. Don't use plaintiff, defendant, appellant, appellee, because it can change as you go up the system. And don't call him Boomer at one point and call him plaintiff at the other, because your reader won't know who you're talking about. Identify him once, give him a name, LCRA, Boomer, whatever, but just stick with that name throughout the brief. That's what I'm talking about with party confusion. Don't be a victim of that. It'll make it easier for you to understand, me to understand, and anybody in the future to understand. Clear? This may be a problem next week. I told you we're going to New York State Court. They don't do things the way they do in federal court. They don't do things the way they do in Texas. If you remember our basic setup, you'll be fine. Trial court, intermediate appellate court, highest appellate court. By the way, if you get confused about what to call something, go with that by default. If you're pretty sure, you think you know this case pretty well, you think you've read it, think you understand the New York legal system, then use the proper name. I'll be super impressed. I will be very impressed if you get it right. You might get a few extra points. But if you're freaking out about it, you don't understand it, trial court, intermediate appellate court, highest appellate court. So no matter what they call it, it's always going to be that setup. So go back and study your judiciary. Oh, this is a huge, huge issue. People ask a question in their issue. Then they proceed to answer a different question, one that they never asked. And then they explain why they answered it with a third set of reasons. Okay? Be consistent. Ask your question, answer that question, not another question, then give me in your reasoning the reason they answered it that way. Okay? Court asks a question, the court answers a question, the court explains their answer to that question. Don't start with 3 and then give me 2 and then 1. Okay? That's what I'm saying. You kind of start with the issue. You have 3 issues. I would say boil it down to your most important issue. That makes it easier for you guys to deal with when you're explaining the answer and the reasoning. Okay? Big, big thing. Answer the question you asked. Don't answer a different question. All right. Toward the end of this week, this is what you're going to look like, guys. Check it out. But by the end of the semester, this will be you. Happy student, glowing student, productive student. Glad that they went through this rigorous process because they're learning how things are done. Guess what? We finished early. I still have about 1/5 of the bottle left. And by the way, Melissa, seriously, this is not real tequila. All right. Hey guys, any questions you have during the week, don't hesitate to email me. And here's the way